I'm Michael Thompson, and I've been practicing criminal defense law in Nevada for 17 years now. There are cases that stick with you, not just for their complexity or their dramatic courtroom moments, but for the sheer injustice they represent, and the profound relief you see on a client's face when that injustice is finally, definitively, unwound. This story, a DUI case from a few years back, is one of those. It began, as many do, with a knock on my office door, but what unfolded was a stark reminder that even with seemingly damning evidence, the truth, when it's meticulously hunted down, can shatter an entire prosecution's case. My client, David Miller, walked in looking like a man who'd seen his entire life flash before his eyes, and it wasn't in a good way. He was facing a DUI charge that threatened to obliterate his career as a software engineer, potentially costing him his security clearance, his high-paying job, and his reputation in the tightly knit community of Henderson. The police report painted a grim picture: weaving, slurred speech, failed field sobriety tests, a breathalyzer reading just over the legal limit. It was an open and shut case, or so the state believed. But Dave swore he hadn't touched a drop of alcohol that night. He was panicked, confused, and utterly desperate. What shocked me wasn't just his fervent denial in the face of such clear accusations, but a single chilling detail he mentioned, almost as an afterthought. The arresting officer, Officer Richard Miller, had apparently been exceptionally aggressive, almost theatrical in his actions, seeming to relish in Dave's discomfort. That detail, combined with Dave's quiet insistence on his sobriety, snagged something in my gut. What was truly at stake here wasn't just a fine or a suspended license. It was David's entire future, his ability to provide for his family, his very identity as a law-abiding citizen. I knew I had to dig deep. Here's what you need to understand about driving under the influence in Nevada. Under Nevada Revised Statutes, paragraph 484C, 110, it's illegal for a person to drive or be in actual physical control of a vehicle with a blood alcohol concentration, BAC, of 0. E8% or more by weight. This is known as a per se DUI, meaning the prosecution doesn't even have to prove you were actually impaired, just that your BAC was at or above that limit. If you're under 21, the limit drops to 0. 0.02%. Then there's the impairment clause, where even if your BAC is below 0, however what, you can still be charged if you're impaired to a degree that renders you incapable of safely driving a vehicle. The penalties are severe, even for a first offense: fines, mandatory DUI school, an ignition interlock device, and a significant driver's license suspension. Subsequent offenses escalate quickly, leading to felony charges, prison time, and permanent impacts on your record. In this case, Dave was facing a first offense, but the ramifications for someone in his profession, which required spotless background checks and security clearance, were catastrophic. A DUI conviction would be a career ender, a scarlet letter he couldn't scrub off, making the stakes astronomically high. That's why these cases, though seemingly straightforward on paper, often involve some of the most intricate and impactful legal battles. David Miller was a man in his mid-30s, soft-spoken with kind eyes that were, on that particular Tuesday morning in my office, wide with a potent mix of fear and indignation. He was a lead software architect at a major tech company with offices in Henderson, a job he'd held for over 10 years, building complex algorithms that powered everything from secure financial transactions to advanced AI. He was married with 2 young children, and his life was meticulously structured, devoid of any significant vices. He explained that on the night of October 17th, he had gone out for a late dinner with a new client at a restaurant in the district at Green Valley Ranch. He rarely drank, especially on weeknights, and certainly not when he was driving or had client meetings. He'd had a single, non-alcoholic craft beer, a popular trend he'd sampled with his client. Around 10:30 p.m., on his way home, he was pulled over on North Green Valley Parkway, near the I-215 interchange, for what Officer Miller claimed was a failure to maintain a single lane. Dave was bewildered. He knew he hadn't drifted. The officer immediately suspected alcohol, despite Dave's calm demeanor. He was asked to perform field sobriety tests, FSTs, which Dave insisted he completed perfectly, and then a preliminary breath test, which reportedly registered 0, 85%. Suddenly, he was handcuffed, his car impounded, and he was staring down the barrel of a DUI charge. The opposing party here wasn't an individual, but the formidable machinery of the state of Nevada, represented by the Assistant District Attorney's Office, specifically a prosecutor known for her aggressive stance on DUI cases, ADA Sarah Jenkins. The timeline was compressed. Arrest on October 17th, initial court date set for early December. Dave recounted the events with a tremor in his voice, his hands clasped tightly. He confessed that the officer's tone, from the moment he approached the vehicle, had been accusatory and dismissive. Dave described trying to explain his lack of alcohol consumption, but the officer seemed uninterested, cutting him off and almost mocking him during the FSTs. This detail, again, resonated with me. Dave wasn't a criminal. He was an upstanding citizen caught in a bewildering, terrifying legal maelstrom. I saw the raw vulnerability, the utter confusion of a man who believed in the system suddenly finding himself crushed by it. I knew I had to fight for him. My investigation began immediately, a deep dive into every facet of the incident. The first step, as always, was to obtain every piece of evidence available from the prosecution. This included the police report, the officer's sworn affidavit, calibration records for the breathalyzer device, and, crucially, any video or audio recordings from the scene. The police report, written by Officer Richard Miller of the Henderson Police Department, was meticulously detailed, describing Dave's driving as erratic, his eyes as bloodshot and watery, and his speech as slurred. It stated he failed all 3 FSTs, the horizontal gaze nystagmus, HGN, the walk and turn, and the one-leg stand. The officer's narrative painted a picture of clear impairment, justifying the arrest and the breathalyzer request. ADA Sarah Jenkins was, as expected, unyielding. She saw a breathalyzer reading above 0. E8, and an officer's report to match. In her view, it was an airtight case. She offered a plea deal that, while reducing some penalties, still included a DUI conviction, which was unacceptable for Dave. My strategic thinking process kicked in. The breathalyzer reading was borderline. Could there be an issue with the device's calibration or operation? Could Dave have had residual mouth alcohol from dental work, or a medical condition affecting the reading? I consulted with a forensic toxicologist, Dr. Eleanor Vance, who reviewed the breathalyzer logs. Her initial assessment, while noting the machine was generally well-maintained, flagged a minor variance in the calibration check performed that week, a small crack in the prosecution's armor. I also hired a private investigator, a former police officer named Frank Morales, to visit the scene. Frank documented the lighting conditions, road surface, and potential environmental factors, like the persistent desert wind, that might have influenced FSTs. These were all standard tactics, but the real key, I suspected, lay in the digital evidence. I filed an aggressive discovery motion specifically demanding all dashcam and bodycam footage from Officer Miller's vehicle and person. The initial response from the prosecution was frustratingly vague, claiming limited footage available, which immediately raised my hackles. This was a common tactic. Disclose as little as possible. I knew police departments generally store all footage. I pushed back hard, arguing that any and all recordings from the time the officer initiated the stop until Dave was processed at the station were material and exculpatory evidence. The tension built. I felt like I was hitting a brick wall. Officer Miller's reputation was spotless. He had a strong record of DUI convictions. My opposing counsel, Ms. Jenkins, was confident, almost dismissive of my persistence. It felt like I was fighting against an invisible force, a preconceived notion of guilt. Then came the breakthrough, a moment I can still replay in my mind like it happened yesterday. After weeks of back and forth, formal motions to compel, and a judge's order, the prosecutor's office finally, reluctantly, delivered a new batch of digital evidence, a large file containing the full dashcam and bodycam footage. It arrived late on a Friday afternoon, just as I was preparing to leave the office. My stomach dropped as I clicked open the first file. The initial minutes showed the standard traffic stop, Officer Miller approaching Dave's vehicle, explaining the reason for the stop. Dave was calm, polite, cooperative. My heart raced as I watched the field sobriety tests. What the police report described as significant swaying during the walk and turn was, on the video, a barely perceptible wobble on a slightly uneven shoulder of the road, exacerbated by a gust of wind, exactly what Frank Morales had identified. The missed heel-to-toe steps were actually perfect. During the one-leg stand, Dave maintained his balance for the required 30 seconds without issues, his arms barely moving from his sides. And the most damning contradiction: Officer Miller's narrative claimed Dave's speech was slurred. Yet, on the video, Dave's voice was clear, articulate, and completely unslurred, even when he expressed his confusion about the tests. The truly shocking revelation, the smoking gun that changed everything, came during the horizontal gaze nystagmus test. Officer Miller had reported distinct and sustained nystagmus at maximum deviation, and onset of nystagmus prior to 45 degrees. But the video showed something entirely different. The officer was moving the penlight erratically, too quickly, and failing to hold it at maximum deviation for the required 4 seconds. He was administering the test incorrectly, making any results unreliable if not outright invalid. It was a complete repudiation of his own report. The legally significant aspect was not just that the FSTs were incorrectly administered, but that the video directly contradicted the officer's sworn testimony in the police report. It proved he was either grossly negligent in his observations or deliberately misrepresented what occurred. I immediately called Dave. His voice was hesitant. "Any news, Michael?" I told him, "Dave, we have it, the video. It shows everything. You did not fail those tests. The officer, he either misremembered or he lied." There was a pause, a gasp. Then I heard a choked sob on the other end of the line. "Thank God," he whispered. "Oh, thank God." The day of the trial dawned with a clear, almost brutally bright Henderson sky. The Boulder City Justice Court, a smaller, more intimate courtroom than downtown Las Vegas, felt charged with an almost palpable tension. Judge Elena Ramirez, known for her sharp intellect and no-nonsense approach, presided with an air of dignified authority. ADA Sarah Jenkins, looking confident, sat at the prosecution table, her stack of documents neatly arranged. We had chosen a bench trial, meaning Judge Ramirez would decide the verdict, not a jury. This was a strategic move, as the nuances of FST administration and video analysis are often better understood by a seasoned judge. My key witness was David Miller himself. I led him through his testimony, detailing his evening, his single non-alcoholic drink, his clear mind, and his confusion during the stop. He recounted how he felt he performed the FSTs correctly, despite the officer's accusatory tone. Then came the cross-examination by Ms. Jenkins. She was skilled, trying to paint Dave as unreliable, suggesting that his memory of the events was clouded by the stress of the situation, that perhaps he was simply in denial about his impairment. She pressed him on the preliminary breath test reading, implying his memory was conveniently selective. "Mr. Miller, are you suggesting Officer Miller fabricated his entire report?" she asked, her voice laced with incredulity. Dave calmly replied, "I'm suggesting his report does not accurately reflect what happened, ma'am." The courtroom was hushed. Next, Officer Richard Miller took the stand. He was articulate, professional, and stood by every word of his report, describing Dave's erratic driving, slurred speech, and the clear signs of impairment he observed during the FSTs. He meticulously detailed Dave's failures on each test, building a seemingly impregnable case for the prosecution. Then it was my turn for cross-examination. I started gently, establishing his training, his experience, his duties. "Officer Miller, you understand the importance of accurately documenting your observations, correct?" "Yes, sir." "And that your sworn report must reflect the truth of what occurred?" "Absolutely." I then began to ask about the FSTs, specifically the horizontal gaze nystagmus. "Officer, in your report, you stated you observed nystagmus at maximum deviation and prior to 45 degrees. Could you describe for the court how you administer that test?" He gave a textbook description. "And do you recall holding the stimulus at maximum deviation for at least 4 seconds?" "Yes, sir, as per my training." The climax was imminent. "Officer, I have here the dash cam and body cam footage from your vehicle on the night of October 17th. Would you care to review it with us?" Ms. Jenkins immediately objected. "Your Honor, this footage has been provided. It speaks for itself." Judge Ramirez, however, peered over her glasses. "Counsel, Mr. Thompson is entitled to cross-examine based on the evidence. Objection overruled. Proceed." The projector flickered to life. The footage played, showing the entire traffic stop. The courtroom went silent, save for the hum of the projector. As the FSTs played, my questioning became sharper. "Officer, can you explain why in this footage you are moving the stimulus rapidly, almost jerking it, during the HGN test?" The officer's face, initially confident, began to drain of color. "And here, officer," I continued, freezing the frame, "you appear to hold the stimulus at maximum deviation for approximately 1 to 2 seconds, not 4, directly contradicting your training and your sworn testimony. Can you explain that discrepancy?" The officer stammered, I may have been slightly off in my timing, sir. It's a dynamic situation. But I wasn't done. I played the walk and turn, pointing out how Dave's swaying was minimal, a slight adjustment to uneven gravel. I highlighted his perfect heel-to-toe steps. Then the one-leg stand, showing Dave holding his foot up for the full 30 seconds, his balance impeccable. Finally, the slurred speech. As the dialogue played, Dave's voice was undeniably clear. The officer's attorney, Ms. Jenkins, looked utterly defeated, her shoulders slumping. The video was devastating. A silent, irrefutable witness that meticulously dismantled every key observation in the officer's report. It was impossible to reconcile his testimony with the objective reality displayed on screen. The room was tense, the air thick with the weight of exposed truth. Judge Ramirez, after reviewing the evidence and hearing the final arguments, delivered her ruling the following morning. There was no theatrical flourish, just a clear, unequivocal statement. She found that the prosecution had failed to prove beyond a reasonable doubt that Mr. Miller was driving under the influence. Specifically, she noted that the dashcam and bodycam footage directly contradicted the arresting officer's sworn testimony regarding the administration and observed results of the field sobriety tests. She stated that while the breathalyzer registered 0.85%, given the flawed FSTs and the compelling video evidence of sobriety, there was reasonable doubt about the accuracy and reliability of that reading in establishing impairment or per se intoxication in this particular case. David Miller was acquitted of all charges. The judge's ruling sent a ripple of relief through Dave's family who were present in court. Dave himself, after the initial shock wore off, simply broke down, burying his face in his hands, tears of pure relief streaming down his cheeks. He hugged me tightly, whispering, "Thank you, Michael. Thank you." The prosecution, represented by ADA Jenkins, accepted the ruling with a curt nod, but the disappointment was clear on her face. For Officer Miller, there were no immediate direct consequences in court, though I imagine internal discussions followed. What happened after for Dave was that his security clearance was saved, his job was secure, and his name was cleared. The stigma of a DUI, which would have haunted him for years, evaporated. He was able to return to his life, his family, and his career, his reputation fully restored. Here's what I learned from this case, and what I hope anyone watching this understands. Never underestimate the power of objective evidence, especially digital evidence. Officer Miller wasn't necessarily malicious. He might have genuinely believed his observations were accurate, or perhaps, in the routine of his job, he became overzealous, seeing what he expected to see rather than what was truly there. This case wasn't about catching a corrupt cop, but about exposing the fallibility of human perception and the critical need for corroborating evidence. The broader legal lesson for viewers is this: always ask for the video. Police body cameras and dash cams are now standard, and they are your most objective witness. If you're facing a situation where you believe you've been unfairly accused, especially in a traffic stop or any interaction with law enforcement, remember that the camera doesn't lie. Warning signs people should watch for include an officer who seems uninterested in your explanations, who rushes through procedures, or whose demeanor is excessively accusatory from the outset. Practical advice. If you're facing a DUI or any criminal charge, invoke your right to an attorney immediately. Do not answer questions beyond identifying yourself, And if there's any chance of recorded evidence, make sure your attorney demands it, thoroughly. My professional insight from this case is that human nature, when under pressure or operating on assumptions, can lead to honest but deeply flawed assessments. It's the lawyer's job to strip away those assumptions and uncover the verifiable truth. Months later, David Miller is thriving. He's back to leading his team, enjoying his family, and recently even got a promotion. He occasionally sends me an email, just a quick update, always ending with a heartfelt thanks. Cases like Dave's are why I do this job. To be the advocate for those who feel powerless, to stand between an individual and the often overwhelming might of the state, and to ensure that truth above all else prevails. It's about fighting for justice, one story at a time. Drop your questions in the comments below, and I'll do my best to answer them. I've got plenty more stories to tell. Dramatic legal battles where the stakes were sky high and the outcome hung by a thread.